Good afternoon, everybody, and welcome to this month's AESIN Tech Talk. In a few moments, I'll be introducing our very special guest today. But first of all, just whilst we allow people to arrive, I want to tell you about the AESIN 2024 conference, which takes place in Gaydon on July the 11th. Come together with fellow industry leaders and experts as we reflect on our achievements and look to the future of the automotive electronics industry. We'll have inspiring keynote speakers, technical presentations, and engaging panel discussions. You'll gain valuable insights and ideas to help elevate your own experiences and your businesses. Sponsorship, I should say, and exhibitor opportunities are available. So today's presentation is called Intellectual Property for Automotive Electronics, Why, How and When. And we'll aim to give an overview of why automotive electronics organizations might want to consider intellectual property rights, particularly patents, and how they go about obtaining IP rights and when is the best time to do so. So today's special guest is Matthew Howell. He is a partner at the leading intellectual property firm Haseltine Lake Kempner LLP. He's an electronic engineer by training. Matthew has written and prosecuted hundreds of patents in his 20-plus year career as a patent attorney. He specialises in electronics-related innovations and has acted for major multinationals, SMEs and startups, including UK automotive electronics companies. Like I say, today's presentation is called Intellectual Property for Automotive Electronics, Why, How and When. So Matthew, the floor is yours.
Thank you, Chris. Hi, everybody, and thanks for having me today. It's a real pleasure to be here speaking to you. Let me just do the share screen thing. So hopefully you can all see that. So yeah, as Chris said, my name is Matthew Howell. I am an engineer by training. My degree is electronic engineering, and I did a stint as an engineer at Marconi in the ill-fated early 2000s before pivoting to a career in intellectual property. These days I specialise in writing and prosecuting patents for electronics inventions, and I have this keen interest in everything to do with automotive electronics. So the talk today is about IP for automotive electronics, and I'm going to try and cover why you might want to pursue IP rights, and as Chris says, in particular patents, how you go about doing that, and when you should be thinking about IP. Now, I'm conscious that the audience today will have different levels of knowledge and engagement with the IP system. So what I'm going to try and do is focus on strategic considerations rather than getting into the weeds too much on detailed sort of procedural issues. But we do have time at the end for some questions, and you can always follow up with me by email directly if you have questions that we don't get to cover today. So let's start by telling something you probably already know. Automotive electronics is a field of rapid growth and innovation. So the chart on this slide is taken from a Deloitte report called Semiconductors, the Next Wave, that was published in April 2019. And what it shows is that the cost of automotive electronics as a percentage of the total vehicle cost has risen steadily over the past 50 years or so, and is projected, or at least was projected in 2019, to reach 50% by 2030. And one of the interesting features of the report for me is that they say that most of the automotive innovations taking place today arise from electronics rather than mechanics. So these next few slides are really just to illustrate that point and to demonstrate the level of innovation that's happening in automotive electronics. So the premise here is that patent filings can be used as a proxy for innovation to quantify levels of innovation to some extent. So with that in mind, what we're looking at in this chart is the number of patent applications relating to electrical safety devices for vehicles that were published worldwide every year since 2014. And what you can see here is a generally increasing trend, which I think is evidence of strong levels of innovation in this area. If you look right at the end there, almost 3,000 patent applications were published in this fairly narrow, at least in terms of sort of patent classifications, It's a fairly narrow area in 2023 alone. And here, as a contrast, what we're looking at is the number of patent applications relating to more mechanical safety systems that were published globally over the same period. And what you can see is there's this fairly sort of sharp decline in the trend since 2019, just under 400 patent applications published globally in 2023. So I think that sort of reinforces the point made in that Deloitte report. And we've got a couple more examples here of sort of innovation in electronic systems for automotive applications. So in this chart, what we're looking at is the number of patent applications relating to drive control systems for autonomous vehicles, again, published globally every year since 2014. And what we can see in this chart is that innovation activity in this area has increased sharply in the last few years. You've got almost 6,000 applications published worldwide in 2023. And I guess that's pretty much in line with the wider sort of general trend for increasing vehicle autonomy. And then finally on this point, this is the last chart, and we're looking here at the number of patent applications relating to LiDAR systems for land vehicles that have been published globally, again, every year since 2014. And again, what we're seeing is a sharp increase in innovation activity in this area over the last few years, although there is a bit of a drop in 2023, and that might be an indication that the innovation in the area of LiDAR for land vehicles might be starting to tail off now. So what we can see then is that there is this enormous growth and innovation in the automotive electronics field, and not just in those three specific areas I've highlighted in the previous slides, but really right across the board, right from the system level, so things like autonomous driving systems, all the way through specific circuits like power converters for EV drivetrains, and right down to individual component or device level things like power semiconductor devices. And we also know that these innovations are really adding value to the vehicles and the systems that they're being used in. So the question really is how do you, as innovators in this space, secure your share of the value you're adding? And the answer, I think, or at least part of the answer, is through strategic use of intellectual property. Now, there are lots of ways that intellectual property can be used to support an organization's business objectives and ultimately help to realize that value. And I've listed some of them here. So this first bullet point is all about protecting market share. And this is really the kind of classical use of intellectual property. So registered IP rights are monopoly rights that allow you to prevent others from dealing commercially in what is protected by the IP. So by using IP to effectively put up walls around your technology and brands, you make it more difficult for competitors to enter your market and take market share from you. Competitors either have to spend time and money finding a way to work around your IP, or else they have to wait until your IP rights expire to sort of safely enter the market. Either way, your IP there gives you time to establish a position of market leadership and to charge a premium for your products. And if you look around various different sectors, you'll see companies like Dyson that have been very successful at using IP in this way. The second bullet on this slide is about licensing. Now, this is a slightly different approach in which you actually allow others to use your IP in exchange for a license fee or royalty. So in this model, your IP is actually directly driving revenue. And this is quite a prevalent model in the semiconductor industry. You're probably aware that it's the basis of ARM's business model, for example. IP can strengthen your negotiating position with competitors and can even help open doors to collaboration. So, for example, say you've got two competing organizations that have complementary IP. What they could do is block each other using their IP. Or instead of blocking each other, they could decide to cross-license their IP to each other, so allowing access to each other's technology, but keeping the IP in place to keep out other competitors. And using IP in this way can be mutually beneficial. So each party gets to produce and market superior products while at the same time keeping the competition at bay. And actually, you might even go one step further. So these two previous competitors might even collaborate to develop the IP that they hold into further better products. I've actually worked with clients who've turned IP disputes where one party's saying that you're infringing my patents actually into opportunities to cooperate and improve revenue and profit for both businesses. And then this next point is really about, what we've seen from the earlier slides. IP rights and patents in particular are often used as a sort of metric or a proxy for innovation to quantify, albeit crudely, the level of innovation in a business. So having patents and potentially other IP rights can really help to reinforce the external perception of your business as an innovator. The other thing to think about here is that an IP portfolio can help to attract investment, particularly if you're an early stage business or a scale-up business. Now, investors will often want to see evidence that their investment is protected to some extent, and IP gives you that by providing those monopoly rights that allow you to keep competition at bay. But the other thing that IP gives you is assets that can be extracted from the business and exploited independently if the business fails for any reason. So investors in tech businesses often like to see an IP portfolio, or at least a strategy to develop and protect IP. And then in the UK, there is a scheme called Patent Box, which can be used by companies that hold patents to reduce their corporation tax liability. And actually, you can make really significant savings under this scheme. So it's well worth exploring if you already have patents. And in fact, some companies have been known to file patents specifically to benefit from the savings that are available under the Patent Box scheme. There was a tech talk on this a while ago, and it's worth looking that up if you're interested in that. And then finally on this slide, and this is a fairly recent development, you can actually now use intellectual property as collateral for business loans. NatWest and HSBC are both now offering IP-backed loan products. So that's maybe something to consider if you're looking to raise funds. So the previous slide was all about what you might the sort of traditional uses of IP, but there are other ways that IP can be used to support your business objectives. And we've seen some quite interesting approaches in the automotive industry over the years. So one thing you might like to think about is opening up your IP to competitors. And you might remember that back in 2014, Tesla did this patent pledge where it said that anybody could use its patents for free. And Toyota actually did something similar for some of its electrical and hybrid vehicle patents in 2019. Now, to me, that approach at first sight is counterintuitive, given what I've said about the fundamental purpose of IP rights being to impede competitions. But if you look a bit closer, you can actually find some benefits to these kinds of approaches. So opening up your IP to competitors could encourage adoption of your technologies. And in fact, one of the stated purposes of the Tesla patent pledge was to encourage adoption of EV technology. And in the long run, the more companies and organizations who are adopting your technologies, the lower your manufacturing costs are going to be as you benefit from economies of scale and greater competition further down in the supply chain. And obviously, greater adoption of your technologies could lead to a bigger market for your products. So even if your overall share of that bigger market is smaller, it might be better from a commercial perspective to have a smaller share of a very large market than a larger share of a very small market. And the other interesting thing that Tesla did with its patent pledge was to make free access to its patents conditional on a user's agreeing not to attack Tesla for IP infringements and not to attack the validity of Tesla's patents. So the effect of that was that any organization relying on the Tesla patent pledge to use Tesla's patented technology had to effectively agree to a blanket waiver of its right to assert its own IP against Tesla and a waiver of its right to challenge Tesla's IP. So actually the Tesla patent pledge put Tesla in a pretty safe position in terms of being challenged over IP itself. And then the final benefit that I see from the Tesla patent pledge and we shouldn't understate it, it actually generated a wave of positive PR. There were huge numbers of stories, not just in the automotive press, but in the wider general press. So that positive PR was there. It increased brand awareness and created some really positive brand associations for Tesla. So there are ideas around opening up your IP to competitors that you might want to explore. The last point on this is a question over altruism. So back in the 1960s, Volvo made a decision to effectively gift its 3-point seatbelt patent to the automotive industry, and that paved the way for the use of those seatbelts in virtually every car now sold. Now, it might have been an act of pure altruism motivated by a desire to save lives and to prevent injury, but I think there's certainly an argument that being known for inventing the seatbelt really helped to establish and solidify Volvo's reputation for safety. Okay, so lots of good reasons to consider IP in your automotive electronics business, but how do you actually go about obtaining and using IP? Well, there are lots of different types of IP. Probably the most relevant to this audience is patents, which protect technical innovations in products or processes, but there are also other registered IP rights, including registered designs to protect aesthetic features, registered trademarks to protect distinctive product names, logos, and other kinds of branding. And there are also unregistered rights like copyright and trade secrets. So those registered rights are all monopoly rights that you can use to prevent third parties from using your invention or your design or your trademark. And you can use those rights in that way, regardless of whether that third party has copied you or has come up with the infringing product independently. A word on trade secrets here. So trade secrets are also a kind of IP right, but they are only of any use if and to the extent that the thing you want to protect can be kept secret. Once the secret's out in the public domain, anybody can use it freely and you can't patent it. And the other thing with trade secrets is that you can't use them to prevent anybody who has independently arrived at the idea. So some pitfalls to relying on trade secrets. Just be very careful if you're going to do that. But for the rest of the talk, I'm going to focus on patents because, as I say, I think they're the most likely to be of most relevance to most of the audience. So if you're thinking about innovating, then I think you should be thinking about filing patents to protect your innovations for all of those reasons we talked about earlier. So this is just a reminder of the basic requirements for patentability in the UK and Europe, and there are similar requirements in other territories like the US. So the first requirement is for novelty. Your invention has to be new in the sense that it has not been made publicly available in any way anywhere in the world before the filing date of your patent application. The second requirement is that your invention has to have an inventive step. And that really means that the invention is more than just an obvious development of something that's been done before. And a practical point here to think about when you're considering whether your innovations might be patentable. My experience of working with engineers on patents is that there's a tendency among engineers to think that everything they do is an obvious development or just a small sort of incremental improvement on something that's been done before. And that's completely natural. The engineer's job is to apply their knowledge to solving a problem. And so once the problem's solved, looking back at it, it might seem that the solution's obvious. And I've had this conversation with engineers hundreds of times. The requirement for patentability is for an inventive step. So there doesn't need to be a sort of quantum leap in technology for your innovation to be patentable. And I always think it's a good rule of thumb to ask the question, has a technical problem been solved in a new way? And if the answer to that question is yes, then there's a good chance that you could have a patentable innovation there. So really the message is, don't just dismiss things because they seem obvious to engineers, because, engineers are highly skilled people and really probably quite a lot of what they do seems obvious to them. But from a patent perspective, good chance that it's not obvious. And then the final requirement I've got on this slide is for industrial applicability. I would think probably any innovation that you're working on here would meet that criterion. So then, how do you go about maximizing the return on your investment in innovation using patents? Well, firstly, I think you need to know what inventions you actually have. So my first suggestion here is that you probably want to develop a system for managing inventions and patents to help you identify the innovations that you're generating and to decide whether and how you're going to protect them. Now, in many cases, a product or system that's in development will actually contain or involve multiple different potentially patentable inventions. So, for example, if you're developing a new sensor system that uses a new kind of transducer, there might be an invention or more than one invention in the transducer itself. And there might be further inventions in the circuitry or the software that you use to process the transducer output signals. So if you've got an invention and patent management system, that will enable you to capture all of those inventions effectively and decide what to do in terms of protecting them. And there will be lots of different factors that go into the process of deciding whether or not to file a patent for a particular innovation. And they're probably going to be sort of bespoke to your business. So, for example, you might be considering the commercial potential of the innovation, the likelihood of copying or competition, the ability to detect whether your invention is actually being used in a competitor product, those sorts of considerations. I guess what I'm saying is if you develop a system or methodology that is bespoke to your business and your business's requirements, you'll be able to identify potentially patentable inventions and make consistent and informed decisions about which of them has the most value to your business and which of them to patent. I think you also need to think about developing a filing strategy. So patents are territorial in the sense that a UK patent is effective in the UK, but doesn't give you any protection in the US. So you need to know where you're going to want to seek patent protection for your innovations. And again, your approach is going to be specific to your business, to your markets, and to your particular goals. You will usually want to file patents in your home market at least, but I think decisions on which other countries to file in might vary depending on things like the technology, perceived importance of the innovation, potential, those sorts of things. But again, developing a filing strategy ensures that you can take a consistent approach that gives you the best chance of achieving the right geographical scope of protection in a cost-effective way. Now, innovation doesn't stand still, and nor should your patent portfolio. Every time you develop a new product or iterate or improve a product, I think you should be considering whether there are potential patents there. And on a related note, I think you need to be keeping your existing patent portfolio under regular review. Patents have to be renewed annually in most countries, and renewal costs tend to increase every year. So you need to make sure you're not paying for patents which aren't adding value to your business in some way, either by protecting innovations or by bringing in licensing income or attracting patent box relief. If a patent isn't paying its way, you should be considering allowing it to lapse by not renewing it or even selling it, perhaps. So now we get to the question of when, and as I see it, really there are two kind of when questions. And the first is when to consider IP in your business. The second is when to file patents. The answer to the first question is now and continuously, or as regularly as possible, because as I just said, innovation doesn't stand still. And I think a good way to ensure that you're keeping a continuous eye on IP in your business is to have somebody within the organization with overall responsibility for IP. Now, that could be a chief engineer or a CTO or somebody else. Even if you don't file any patents, it's good to know what IP you have in your business already and where IP is likely to arise in the future, so that you can capture it and make those informed decisions about what to do with it. And if you're in a position where you haven't already considered IP, think about having an IP audit carried out. That's something a patent attorney can help with, as well as help developing an IP strategy. And there may even be funding available to help you with that via Innovate UK and the UK Intellectual Property Office. The point here really is that if you know what IP you already have and where and when IP might arise in your business in the future, it'll be easier to develop a strategy to maximize the value of IP to your business. So then the next part of the when question is when to consider patent filings. What are the triggers for that? And I think the answer to that is ideally, as I said, consider patent filings whenever you come up with a new invention or an improvement to an existing technology. Really, what I'm trying to do here is reinforce the point that innovation doesn't stand still, and your patent portfolio shouldn't stand still either. You need to be protecting new innovations when they arise, if that's appropriate and in line with your overall strategy for your business. Now, there are some requirements around when you file your patent application. So a key requirement is that you must file your patents before there is any non-confidential disclosure, whether that's a product launch, a public display, marketing literature, press releases, and even discussions with customers or potential collaborators. Otherwise, the risk is that you destroy the novelty of your invention, and therefore any patent that you might eventually be granted ends up being invalid. And there's a balance to be struck in terms of the timing of filing a patent application. There's a common misconception that you need to wait until you've got a working product or a prototype. You absolutely don't need to wait until you've got a working product or a prototype to file a patent application. But on the other hand, you shouldn't just fire off an application as soon as you come up with an idea. So one of the requirements of the patent process is that the patent has to disclose the invention in sufficient detail to allow it to be put into practice. And what that means is that you need to be able to provide a detailed description and drawings which plausibly explain how you implement the invention. Now, it might take a bit of time to get to a point where you know enough to be able to explain how to put the invention into practice, but that's likely to happen well before you get to the stage of having a working prototype. And it's at the point where you have enough of that information that your patent should be filed. So to summarize then, as we know, automotive electronics is an area of huge growth and innovation. As innovators, you can use IP to help you to protect and realize the value of those innovations. And the first step is to know what you have. And then you can develop a strategy to capture and protect future IP as and when it arises in your business. In terms of the when, I think you should be thinking about IP now, but remember also that innovation isn't static. So your IP position shouldn't be either. Keep it under review, manage it proactively to maximize its value to your business. And finally, probably obligatory, a plug for our firm. Haseltine Lake Kempner can help with all of this. We've got lots of experience in helping organizations to develop strategies to identify and protect IP in a cost-effective way, and in the sort of procedural side of writing and prosecuting the patents that protect those innovations. So do feel free to get in touch if you want to talk about that. But that's me. Thank you very much for listening. I hope that's been useful, and we have got some time, I think, for some questions if anybody's got any.
Thank you very much indeed, Matthew. Next month's AESIN Tech Talk will be with our special guest, Saket Mohan of Secure Elements. It takes place on the 22nd of May at noon BST. Saket Mohan is the founder and director of Secure Elements. He is an automotive tech enthusiast and has an industry experience of 12 plus years in connected cars and automotive cyber security. So we're now into the Q&A section of today's broadcast. And Matthew, if I could ask you to come out of your slides. One of the things I was wondering about, and this is obviously not quite automotive related, but you'll see where I'm going with this. One of the most famous patents in the world is by Levi Strauss, the pocket design, the tab, etc. And they've spent decades with litigation enforcing their patent, and they've made millions from that. So previously, you were talking about how Volvo gave away the the patent for the 3-point seatbelt because it would save lives. And you were talking about Tesla and Toyota giving away patents for free. Surely the exclusivity is of far more value to the likes of Tesla and Toyota, along the lines that if you want this particular feature in your vehicle, you have to buy a Tesla, you have to buy a Toyota. Surely that exclusivity is worth far more than having a kind reputation within the industry, if you like. Now, I know you elaborated on the reasons why, but I'm wondering if you can talk a bit more about, the profitability of exclusivity and the money you can make through litigation versus just being one of the good guys.
Yeah, absolutely. I mean, I think Levi's is a good example of that, and absolutely you're right. Exclusivity is gold, isn't it, in the marketplace? And if you've got patents that give you that exclusivity, that allow you to prevent competition, then you're already in a winning position. And I think, I mean, I should just, as a sort of tangent, you don't always have to litigate to maintain that exclusivity. And in fact, most patent disputes, I would say, don't end up in the courts. What tends to happen is somebody says, I've got a patent, you're infringing it for these reasons, please stop. And then there's a sort of exchange of correspondence, and the dispute settles. Either the infringer stops, or there's a license agreement put in place, or the infringer sort of works around. So it doesn't always have to go to the courts. But yes, if you've got a patent that stops people from entering your market, you can charge more money for your products because they've got features other competitors don't have. You can get way ahead in the marketplace. One of the other things is that patents are time limited, so you get a maximum of 20 years. So after 20 years, anybody could have used that Levi's patent for the studs on the pockets of the jeans, the rivets rather. But by having that patent and enforcing it, Levi gets that market exclusivity, and it helps to generate the brand recognition that keeps people coming back even after the patent has expired. And Dyson is another good example of that kind of use of patents. So yeah, I mean, I think going right back to the original question, the exclusivity is definitely where most of the value is, and that's how patents have tended to be used in the past. I guess that the Tesla and Toyota examples were about alternative ways that you can turn IP to your advantage.
Okay, thanks for that. What is the relationship with patents and open source, Matthew?
An excellent question. So we could talk about this all day. So open source. The first thing to say is that it is possible to patent open source technology that you've developed. The key thing here is that there are lots and lots of different kinds of open source licenses. From at the far end of the scale, there's the sort of copyleft where you have to allow free access to all of your technology. And then on the other side, there are more, I was going to say permissive, but it's not quite the right word. But there are more. There are open source licenses which do allow a degree of exclusivity. So really, it's about, you need to know what the open source license says about allowing access to any development or any technology, and just being aware of it. Yes, you can file patents, you can get patents granted for open source stuff. You just need to make sure that you know what the implications of that are, so you don't go around trying to enforce a patent that actually, under the open source license, is freely available to everybody.
Okay, thanks for that. I want to talk about trade secrets and confidential information. What are the risks of relying on that?
Yeah, I mean, so I guess the headline here is that it's the clue is in the name. If it's a secret or if it's confidential, it's only worth anything while it remains secret or confidential. As soon as you can't get the genie back in the bottle. As soon as that information is out in the wild, anybody can use it, and the only sort of remedy you have is to sue for breach of confidence, which might get you some financial damages for the breach, but it won't stop subsequent use of your trade secret or your confidential information. So really, you need to be very, very careful if you're using trade secrets or confidential information, that you absolutely lock that information down. You've got to restrict access. It's got to be really properly, strictly need to know, and that you make sure that there are sort of contractual provisions for employees so that they can't walk off with that and use it if they leave your organization.
Thank you very much for that then, Matthew. That brings things to a close today. As I said previously, the next AESIN webinar is on May the 22nd at noon. Our special guest will be Saket Mohan of Secure Elements. Saket Mohan is the founder and director of Secure Elements. He is an automotive tech enthusiast and has industry experience of 12 plus years in connected cars and automotive cyber security. I mentioned that at the start of the broadcast. Oh, and by the way, if you're watching this broadcast live, by the way, I'll put the link to register for next month's AESIN Tech Talk into the Zoom chat facility. So if you just scroll up a little bit and click on that, you can register for next month's Tech Talk right now. I've also put a link in for details of the 2024 AESIN conference, which I mentioned at the start of the broadcast, just whilst everybody was arriving. It's going to take place on July the 11th in Gaydon. And this year's conference theme is Collaboration in a Technology-Rich Era. We'll be celebrating the UK's outstanding automotive electronics-related organisations as we bring technology to the forefront. This year, we'll be heading to the British Motor Museum, which is in Gaydon in Warwickshire. The British Motor Museum holds the world's largest collection of historic British cars, with over 300 vehicles on display from the British Motor Industry Heritage Trust and the Jaguar Heritage Trust as well. And sponsorship and exhibitor opportunities are available if you're interested in that. Once again, thank you very much to you, Matthew, our very special guest today. That was absolutely fascinating. Thank you so much for your presentation. I know these things take a lot of preparation, and then you've got to rehearse them, refine them, etc. So they do take more time than I think a lot of people realize. So we're very grateful for that one. So we'll wrap up today's broadcast. Thank you very much to Matthew once again, and thank you to everybody for joining us today.